Court does call the case. People versus Nicole Henderson. Your name?
Nicole Henderson.
You are before the court on a misdemeanor complaint that alleges that on or about April 12th, 2026, location of Gulfside Road near Washington Road, that you committed the offense of operating while intoxicated or impaired, second offense. You understand that, ma'am?
Yes, sir.
That is a misdemeanor punishable by up to 1 year in jail, $8,000 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
Public defender case.
Brown appearing on behalf of Ms. Henderson, waive reading stand, request adjournment.
Defendant every way from a reading standing mute. Court will enter a not guilty plea. Pretrial will be set for June 17th, 2026, 9 a.m. Has the bond.
May I approach, Your Honor, with the prosecutor?
I would also ask to approach, Your Honor.
Yes, you
And what is
Just listen.
may. Record should reflect we've had an extensive bench conference in this case, trying to figure out the defendant's record. My understanding, first of all, that there is, as to her bond, that there's a prior offense in 2022. There is a current pending drunk driving from I think it was 2025.
Correct.
2025. Out of that, and this becomes important, that case is still open. There is also, from, I believe, that offense, an implied consent violation. And out of that implied consent, her license or driving privileges in the state of Michigan were suspended from the date of, I just want to make sure I have the dates correct, but
July 20.
from July 12th, 2025 to July 11th, 2026. So as we sit here today, her driving privileges are suspended. I then have that. So in April of this year, this alleged offense, she was issued a 625G, but she cannot drive on that 625G because of the implied consent. She had no license at that time. At the time that this offense allegedly occurs, she also then has an open drunk driving case out of another jurisdiction and has the prior. And then she is here allegedly in this case with a 0.235 blood alcohol. Brown, is there anything you want to say on behalf of your client regarding bond before the court fixes bond?
Your Honor, she's employed at General Motors in Lansing. She has a 4-year-old daughter that she cares for. She works from 10 p.m. until 6 a.m. I mentioned sidebar that she does have a prepaid, pre-planned trip before all of this. And I'd ask the court to consider a reasonable bond in this case so she can save her job and take care of her 4-year-old. A scram monitoring device.
Anything from the people?
Your Honor, not to recount everything that was discussed at the bench, I have significant concerns for this defendant's ability to remain sober, compliant with her bond conditions. I also have concerns about her returning to court at future dates, given the multiple warrants and given that she knew that she had those warrants at the time of this offense and told the officers essentially she was on the run from those warrants for reasons discussed at the bench, which again, some of those are private. I'm not going to get into on the record, as well as those reasons. I would ask this court set a relatively significant cash surety bond with, if the defendant were to post that bond, scram and GPS tracking tethers in case she does fail to appear, we can at least know where she is at that point.
However, standard conditions, including no assault behavior, possession of any weapons, firearms, ammunition. It will also indicate that the defendant is not to possess and or consume any alcohol, recreational marijuana, or any illegal drugs. You do understand that, ma'am?
Yes.
I am going to say I consider, given all of those circumstances, that the defendant is a significant risk to the public as well as to herself, because she cannot stop drinking and then operating a motor vehicle. It just seems at this point she is fortunate that she hasn't taken somebody out. She's a 0.235 at this instant, with a pending drunk driving and a prior, all occurring within the last 7 years. She's not supposed to be driving because she doesn't have a license, because she didn't take a test on one of these occasions. And the only license that she would have would be a 625G permit, which she can't drink and drive on. She's not supposed to be drinking and driving. Since I consider this defendant to be a significant risk to the public, and we can try to figure it out, her bond is set in the amount of $1,000 cash surety bond. The defendant is remanded. She must be placed, if she posts that bond, on a scram tether and a GPS tether prior to her release. Defendant's remanded.
Court date?
Thought I gave you one. June 17th, 9 a.m.
Thank you.
Location track.
As this hearing came to a close, the judge made it clear that public safety was the court's top priority, with a prior OWI conviction, a pending drunk driving case, a suspended license, and allegations of driving with an extremely high blood alcohol level. The court determined that strict bond conditions were necessary. While the defense highlighted the defendant's job and family responsibilities, the judge ultimately concluded that the risks were too significant to ignore. Thanks for watching. Please like, share, and subscribe for more courtroom cases and legal analysis.